as I always say, any business done on a handshake will ultimately lead to a different kind of hand gesture. So you have to really protect yourself. Just a little background on contracts. There's going to be like a quick law school 101. So to have a contract, you need three things: offer, acceptance, and consideration. So for example, if you say, hey, Neil, I want to buy your car, I'll give you $500. That's an offer. And I say, sure, that's acceptance. And the consideration is $500. So if later you come by to give me $500 for the car, I say, oh, I just sold it to Jacob Busani, you actually can sue me for breach of contract. We have an oral contract. It's okay. It doesn't have to be in writing. Oral is okay. The thing is that if it's oral, you have to prove the contract, prove we had offer, prove we had acceptance. If you have it in writing, you just say, hey, look, here's the contract, and it proves itself. Okay, there's something in real estate called the statute of frauds. Things must be in writing. Now, I'm a big proponent of everything being in writing. So if you ever want to, let's say, an open house, you want to look at a house, and you want to make an offer, the broker shoves papers in your face here, sign this offer. And the reason they do that is because it has to be in writing. Not that they're pushy, though they might be pushy. Anyway, so in my opinion, as I said, everything should be in writing, and you want to make sure that your contracts are well written because, as I said, it is the backbone of your business. Okay, so let's talk about what kind of contracts you actually need. So the first ones, and these are the most important to me, are operational documents. Now, operational documents, I'm going to assume for the purposes of the conversation that whatever business you're running through an LLC, a limited liability company, or a corporation. Now, if you're not running your business through an LLC or a corporation, as soon as possible, you should form one and start doing it. Wait till I'm finished speaking, so at least you'll get everything I want to say. But the point is, you have this gift. It's a way of separating your business assets from your personal assets and protecting you. It gives you limited personal liability. You don't have to worry about things. And I'll give you some example of how it works. So you form an entity. It's a separate legal entity. It has its own existence. It operates independently of you. It has its own EIN, which is like a social security number for businesses. It's not an extension of yourself. It's not an alter ego. It's separate and apart, and it limits your personal non-business assets from being taken in any kind of liability or anything like that. I'm going to give an example. Let's say you own a business as a sole proprietorship or as a partnership, meaning you don't have an LLC or a corporation. So you're going to have unlimited personal liability. Let's say you own a dry cleaner, and it's owned by Neil Greenbaum owns a dry cleaner, and it incurs $100,000 of liability. Well, if the dry cleaner only has $50,000 of assets, what they're going to do is they're going to take the $50,000 from the dry cleaning business, and that's going to put the dry cleaning business out of business. And they're going to say, hey, Neil, you own the dry cleaning business, so now you're on the hook for the rest. They're going to get the other $50,000 from me personally. Now, where are they going to get it from? My house, stocks, bank account, fur, jewelry, paintings, family heirlooms, whatever it is. They're going to come after me personally because I own that business in my personal name. Now, if I formed an LLC or a corporation and I owned that dry cleaning business under, let's say, ABC LLC, well, what would happen is they go after ABC LLC as the owner. So as I said, the dry cleaning business had $50,000 of assets and they have a judgment for $100,000. Well, they'll sink the dry cleaning business because they'll take the $50,000. But when they want to look at me, I could have $50 million of assets. They can't come after me personally because I formed that LLC, because I thought ahead and took care of it. So what's the process of actually forming an entity? It's not very difficult. You go on a state level and you file articles of incorporation or organization. You obtain the EIN, which I said is like a social security number for a corporation or a LLC, and you draft operational documents. For a corporation, it would be shareholder agreement and bylaws, and for an LLC, it would be operating agreement. Now, it's extremely important that you only have one entity per business. A lot of people have multiple lines of business, and sometimes they say, oh, you know what I'll do? I'll save money. I won't form 10 entities. I'll form one entity and I'll have everything under one entity. Here's the problem. Let's say you have two totally different businesses. Say one is a mold remediation business and the other one is a pizzeria. So in this instance, a mold remediation business would probably incur far more liability than a pizzeria, unless it's a really bad pizzeria. So let's say they're both owned by one entity, ABC LLC. So what happens is ABC LLC is the owner of both businesses. So whoever's going to come sue is going to sue ABC LLC. Now, let's say it's $100,000 liability and the mold remediation business has $50,000. So that's going to sink the mold remediation business. But because they're both owned by ABC LLC, they're going to be able to go after the pizzeria as well. And if the pizzeria has $50,000 of assets or less, they're going to sink that business too. So both businesses will be sunk because it was one entity. Let's say you were smart about it and every business had its own entity. So the mold remediation business was owned by ABC LLC and the pizzeria was owned by XYZ LLC. Well, if ABC LLC incurs $100,000 of liability, and the mold remediation business only has $50,000 of assets, it'll sink the mold remediation business. But they're not going to be able to get any money out of the pizzeria. It's owned by XYZ LLC, a totally separate company, even if you own both. The pizzeria could have $5 million of assets. They're not going to be able to touch it. So that's called cross liability when you go against both. So whatever business you're in, if you have more than one line of business, separate entities for each, okay? It's worth the money you spend because in the end, it'll save your businesses. Okay, so what type of operational documents do we need, and what are operational documents? So operational documents, they talk about the management and the operation of the business. They're going to name who owns the business. Let's say, who manages the business. In an LLC, it could be managers, it could be members. In a corporation, it would be directors or shareholders. And it's going to discuss what their duties are and what their roles are in the business. And it's important that this be in writing, because if you don't have things in writing, that's where you have vagueness. And when there's specificity, you don't have problems. When things are vague and amorphous, that's where you have problems. So what else would operational documents talk about? Voting. Well, who votes, what is voted on, and what is the percentage? Just because you own a business, let's say two people, 50-50, doesn't mean the voting is 50-50. You can have each person own 50% of the business, but the voting is 60-40 or 70-30 or however else you might agree to it. And if it's in writing, that's what it's going to be. And it won't be something that you have to fight about later on. How about capital contributions? When you start a business, a lot of times people will say, I'm going to put in 50,000, you put in 50,000, but not everyone puts in the same amount of money. Now, does that mean they don't own the same amount? Well, some people are sweat equity partners. Somebody might be investing, the other person might be working it. So you want to have in your documents exactly who owns what and who's investing what. In terms of members and shareholders, you want to know who they are, who are the owners, and what do they own, and what are their rights, and what are their obligations. You want to know about distributions. When are distributions made? If you have profits, are distributions made quarterly, monthly, semi-annually, at all? You have to hit a certain level, is there a certain threshold? How about transfer of interest? Let's say you're in business with somebody and they die. Do you want to be in business with their surviving spouse? You might not. Do you want to be in business with their kids? You might not. So there are things you can do. In your operational documents, you can have a buy-sell agreement whereby life insurance buys out the other partner's family upon his death, or a right of first refusal where the company has the right to buy the shares upon the death of somebody. You don't want to wake up you don't want to go to business with somebody on Monday and wake up on Tuesday and be in business with someone else. So the way that you take care of this is by having it in writing and taking care of anything that might happen. Dissolution. When do you dissolve a company? Do you vote on it? Is it only when you go bankrupt? You might want to make sure you know in advance what you're doing. And information rights. Let's say you have a company and somebody knocks on the door Wednesday at 5 to 5. We're about to close up. It says, hey, I'm a 1% owner of this business. I want to see all the books and records right now. Now, it doesn't work that way. That's going to cause problems. What you want to do is say books and records are looked upon. You could look at it upon 24 hours written notice and this and that. You have to come to the office. You can't make copies. The point is this: when it comes to documents, if you have things written down and things are in black and white, it's easy to make sure that there are no issues. So forming an entity, an LLC or corporation, is imperative, as I said. But it's not just forming it. You have to operate it correctly. Because if you don't operate correctly, you can get into trouble. There's something called piercing the corporate veil. And I said before, that sounds like a Game of Thrones episode. But what it is if somebody's going after your entity for liability, they want to pierce through it and go after you personally. And there are ways that people are able to do this. The first is they want to prove that the company is really just an alter ego or a sham. So it's an extension of yourself. The first way is commingling. When you have a business, you have to have separate bank accounts, separate credit cards for your business. You can't pay your rent or your mortgage from your business account. You don't take personal checks deposit into your business account or business checks and deposit into your personal account. You have to keep things separate. If you commingle your funds, that's going to be a key way that somebody's going to try to pierce the corporate veil and go after you personally. Another way is fraudulent conduct. If you commit fraud, the courts will allow piercing the corporate veil. So if you have an LLC or a corporation, it's not going to matter. If you commit fraud, it's going to be a way to go after your personal assets. Another way is through personal contractual guarantees. And this happens a lot. If you sign a contract as an officer or as a member or as a director of a LLC or corporation, then the LLC or corporation will be on the hook and you will not have personal liability unless you sign a personal guarantee. It happens a lot with commercial leases. Let's say you're taking office, warehouse, retail space. A lot of times they want somebody to personally guarantee the lease. Now, I would say the best answer in that situation is no, I don't want to personally guarantee the lease. But if you have to, don't do a complete blanket guarantee of a lease. There's always, you can limit it to time, you can limit it to dollar amount, or have a 6-month rolling where you're not on the hook for everything. Remember, if you sign personally, it doesn't matter if you have an entity that's limiting your personal liability, you're still going to be on the hook. So why do you need these operational documents? And the reason is you need a shareholder agreement and bylaws for a corporation, and you need an operating agreement for an LLC because there's going to be disputes. I don't care who you're in business with. Your significant other, your fraternity brother, your fellow bridesmaid, the kid you grew up with for the last 50 years. You're going to have disputes. When it comes to business, we all know these stories where like families have fought like cats and dogs over business because business is money. So you might be asking, well, what if I own the business by myself? Why would I need operational documents? I'm not going to fight with myself. That seems absurd. So here's the reason. Remember I talked about piercing the corporate veil. If somebody's coming after your business and you own it by yourself, it's sort of easy to prove it's an alter ego of yourself unless you're keeping things 100% separate and you're really running it like a business and not like it's some kind of sham. So if I'm coming after you and you're the sole owner of your business, either a single shareholder or a single member, what I'm going to ask you for first is a copy of that operational document. Let me see your operating agreement. Let me see your shareholder agreement. And if you're like, humana, I don't have one, then I'm going to say, wait a second. You're claiming you have an LLC or corporation, but you don't have the single foundational document behind that. To me, that shows that it's a sham. It's just an alter ego. And I'm going to use that to go pierce the corporate veil against you. So if first of all, you should be doing business as an LLC or corporation. To do it otherwise makes no sense as far as I'm concerned, because you're going to limit your liability and save all your non-business personal assets. But once you have that corporation, you have to make sure you're operating correctly and you have operational documents. So operational documents, number one, shareholder agreement, operating agreement, bylaws, you have to have that stuff. And a lot of people form their own entities and they just don't get around to getting that stuff. They don't bother. People come to me all the time like, okay, we're taking a loan out or we're buying something or selling something. I go, let me see your operating agreement. Like, we don't have an operating agreement. And they've been in business for 10 years and they're doing well. They just don't have foundational documents. And it's dangerous. There's no reason not to have it. There's a cost involved, but the cost is usually well worth it. Okay, so operational documents, the first type of documents you should have for business. And by the way, if there are any questions, just please chime in. The second type of documents are restrictive documents. And these documents have restrictive clauses. They restrict people from doing certain things. And there are four primary ones. And the first one is non-competes. So a non-compete agreement would be where you restrict somebody else from competing with your business. And this is going to be usually an employee or perhaps a former partner that you buy out or who leaves or retires. And the reason you're going to have a non-compete is because let's say you buy out your partner, you have two partners, and you buy him out and you give him $100,000. He takes $100,000, he goes across the street, he uses the money you just paid him to open a competing business with you. Well, obviously you don't want that to happen. Or if you have an employee who you bring on, you train the employee, you teach the employee, you show the employee the industry, you show the employee the business, you teach them all the tricks, and then they quit and go across the street and open up a competing business. You don't want to have that. So you must have non-compete agreements with these people. Now, non-compete agreements have to be reasonable in terms of three things. You can't just say, you can't work in any similar business anywhere in the stratosphere until the end of time. That's too broad. You have to really tone it down and focus it. Three things. So sorry about that. So three things that it has to be reasonable in terms of time, in terms of geography, in terms of scope. So like I said, time until the end of time won't work. A year or two is probably a reasonable amount of time. Geography, stratosphere, anywhere in the stratosphere is not going to work, but it should be like within X amount of miles, or perhaps this county or this state. And then scope. Let's say you're in a business, let's say a bakery business. And let's say we'll make it even more focused. Let's say you have a kosher bakery or a gluten-free vegan bakery. How about kosher, gluten-free vegan bakery? How's that? That's pretty focused. Okay, well, if you're going to have a non-compete with somebody, you're going to say you can't go into the kosher, vegan, gluten-free bakery business. You're not going to say you can't sell baked goods. It's too broad in scope. So if you have a non-compete and the non-compete is focused in terms of time, geography, and scope, it's going to hold up and you're going to need it. It's going to protect you. If you don't have it with the right people, they're going to be able to compete with you and it's going to affect your business negatively. All right, the second type of restrictive document is a non-disclosure agreement. NDA, a confidentiality agreement, has a bunch of names, but it all does the same thing. So this restricts somebody's ability to discuss certain matters with other people. So who would sign this? An employee would sign an NDA. Consultant, if you have any consultants come into your business and you're going to teach them things, they're going to sign an NDA. Maybe someone you have a strategic alliance with or a joint venture with. Now, what does an NDA cover? An NDA will cover proprietary, non-public information. So it has to be something that you own, something that's not public, that everyone doesn't just know it exists. So, for example, you can't have somebody sign an NDA and you have them sign it and they say, okay, the sky is blue, or George Washington is the first president. You can't tell anybody that. Well, obviously they can. That's not proprietary. It is public. Everyone knows George Washington was the first president of the United States. I can tell anybody I want. I don't care what I sign with you. It'll never hold up. So but if you have proprietary, non-public information that you want to protect, that's what you want to get into the NDA. So what can an NDA cover? It's not going to cover George Washington. It's not going to cover the sky is blue. It can cover client or customer lists. Who are your clients and customers? I mean, that's important information. It's proprietary. It's non-public usually. Maybe you have a marketing plan that you want to cover, perhaps pricing structures that you use, business methods, formulas, algorithms, codes, whatever it is, things that are proprietary to your business that are important. You do not want other people to have, because if they get that information, it will be detrimental to your business. And you want to make sure that you protect it. Another type of restricted document would be the customer non-solicitation agreement. So this restricts people or business from soliciting your customers or clients. And who would you want to have sign this? Anytime an employee or a partner departs your business. Somebody who's on your side, that's great. Once they're not on your side, it's like free reign. They're going to come after your customers. They know who your customers are. They've worked with you before. You're going to want to have them sign something if they're leaving, that they cannot solicit your customers. So it can even be somebody you have a joint venture with. Maybe you do a joint venture or you go into a special project, something specific. Well, you're going to be giving certain information to people. You want to make sure that they cannot go after your customers. The final restrictive document I'm going to talk about is a non-recruitment agreement or a non-poaching agreement. And this has to do with employees. So it prohibits people from recruiting or hiring away your employees. Listen, employees are important. You have a big investment when you have employees. When employees come in, you train them, you teach them the ropes, you teach them your methodology. Now, your methodology might itself be proprietary. If they had their hands on your methodology, then they'd be able to compete with you more. So you want to make sure that nobody can recruit these employees, because these employees have the methodology, and these employees should also be subject to an NDA, a non-disclosure, so they can't disclose that methodology. So even if they don't work for a competitor of yours or somebody who's in the same industry or business as yours, you don't want them telling you. You don't want them, having coffee table talk and giving your business secrets and your algorithms away. That's going to get you in trouble. It will fall into the wrong hands. So operational documents are extremely important. Restrictive documents are extremely important. The third type of documents are worker documents. Now, if your business has employees, congratulations. You've gotten to the level where you hire employees. That's a big deal. But like they say about a boat owner, the two best days of a boat owner's life are the day they buy the boat and the day they sell the boat. Because when you do have employees, you have tremendous responsibility. So there are two types of workers. I'm going to call them workers. It's just more of a generic term. So there are employees and there are independent contractors. And the real difference between them is a degree of control. If you tell somebody, like, we're working Monday through Friday, 9 to 5, and you get 12 to 12:30 for lunch, you have a lot of control over them. If you tell somebody, here's a project I want you to do, I need it back in 2 weeks. I don't care when you do it, just do it in 2 weeks. You can do it in the middle of the night, at home, at Starbucks, in the bathtub, just get it done. That's going to be less control, but they're going to have a job to do. So if you control where or when somebody works, or how they're paid, if they're reimbursed for certain things, if they get benefits or vacation, or if there's a continuity of relationship, then they probably would be an employee as opposed to an independent contractor. Remember, an independent contractor could be hired just for a project. When the project's over, you guarantee that they're to continue on another project. It just ends. So with employees, you have added responsibilities. And this is the big issue between employees and independent contractors. And I'm going to get into the documents you need in a second. I just want to explain it so you understand first. So if you have employees, you have to withhold income tax. You have to pay Medicare taxes. You have to pay Social Security and unemployment tax. And you don't have to do any of this with independent contractors. So with employees, you have these added responsibilities and added obligations. You're on the hook for certain things. So of course, if you're thinking to yourself, how can I get around this? Oh, I got it. I'm going to make everybody an independent contractor. If they're all independent contractors, then I don't have to worry. If they're employees, I have all this thing to do. I'm going to make them independent contractors. I'm going to beat the system. Okay, so here's the problem. If it looks like a duck, it quacks like a duck, it's a duck. It's not an elephant. So if it's somebody who you control and they have to be in your office X amount of time and they have certain tasks and they take lunch this time, they have vacation days this time, they have benefits, they have continuity of employment is confirmed usually, they're going to be employees. You can't call them independent contractors. And if you say to them, here, sign this document, it's an independent contractor agreement, even if they're employees, you can't pass them off as independent contractors, because whether they're independent contractors or employees is not your decision. You know who actually makes that determination? The IRS and the Department of Labor. And those are two offices you don't want to mess with, because if you actually misclassify a worker on purpose as an independent contractor and they're really an employee, and you do it so that you can get around paying for all these things or having these extra obligations, you're not only going to have to pay the back taxes, but you're going to have penalties and fines. So let's say you determine whether somebody's an employee or an independent contractor. Now, what documents do you need for them? So if they're an employee, employment agreement. An employment agreement will detail the relationship. You can't just say to somebody, oh, welcome aboard, payday's Friday, see ya. You have to tell them what their job is. You have to give them, this is your position, this is how much you're getting paid, this is how long you're going to be with us, this is your compensation structure, this is, why you might be fired. And if you don't do that, you're going to run into trouble. You want to get things in writing, and every employee should have an employee agreement. The employment agreement doesn't mean that you're an employee with us for 10 years. They can be at will, which means they can be fired at any time or they can quit at any time. But you want to have in writing what the parameters of their employment are, because then there's no room for uncertainty and there's specificity. Okay, so what would be included in an employment agreement? Term, how long is the employment for? Is it like a 1-year contract and then it's renewable, or then they leave? Or is it at will that you can fire them at any time or they can quit at any time? Position, what is their job title? What are their duties? What are their responsibilities? What's expected of them? Compensation, how much are they paid? How often are they paid? Bonus, is there a bonus structure involved? Cause of termination. Can they be fired for any reason, for no reason, for certain things? And what happens there? Is there a severance? Is there no severance? So you want to have that in writing, because if you have it in writing, it's not something you have to think about anymore. They come in, you sign an employment agreement, and it's done. Now, when do you have an employee sign an employment agreement? Before they start or the day they come into work? You don't wait, because if you hire somebody and like 6 months later, it's like, oh, I want you to sign this employment agreement. First of all, you have a hard time with consideration. Remember I discussed offer, acceptance, and consideration? They already had the job. If you offer them a job and they accept it, and the consideration is I'm going to pay you, well, they already have that, so it's past consideration. So you should always have your employment agreements ready before you hire the employees, and they should sign it either right before they start or the day they come to start. Let's say somebody's not an employer. Let's say they're an independent contractor, because they don't have that. You don't have that total sort of control of them. Well, they need an independent contract agreement, which is similar to an employment agreement. It's a little bit different, but it's similar. And it would discuss things like term, like how long are they hired for. Now, unlike an employee who's going to be working, I assume, 52 weeks a year, except for vacation, and has an expectation of staying on, an independent contractor might be per project. What are the fees? Not getting salary, but maybe they're being paid per project or per time period, whatever it is. And what's the relationship of the parties? An independent contract agreement must state in it that this is not an employer-employee relationship, because you want to make it clear. Because if an independent contractor is under the impression that they might be considered an employee, they're going to want those things that employees get. They're going to want benefits, and they want Social Security and FICA. They're going to want all that stuff. So you have to put in your independent contract agreement that it's not an employer-employee relationship. Okay, so let's say you have an employee. You need one more thing besides the employment agreement, and this is important, and a lot of people don't have this, and it's something you really should have. If you have one employee, you should have it. If you have multiple employees, you better have it. It's an employee handbook. So an employee handbook will communicate what is your company's mission, your procedures, your policies, your rules, regulations, and because people can't follow rules if you don't spell it out. If you spell something out and it's there in black and white and you give it to them and they see it, they're going to understand it. And also it's going to protect you. So why would you want an employee handbook? Because a lot of people don't have them. So first of all, you want to be able to welcome your employees and say, here's our expectations of you. Here's our rules. Here's our procedures. Here's our anti-harassment procedure. Here's our smoking policy. Here's this. And also, when you give them an employee handbook, you want to have them sign an acknowledgement. I received the employee handbook. I have it. I understand. I read the employee handbook, or I'm undertaking to read the employee handbook. So you want to know that they received it. That was their obligation to read it. So if they ever say, oh, I didn't know, well, listen, you signed an acknowledgement and you said you're going to read it. So you can't say I didn't know the policy existed or the policy didn't exist. It's right there in black and white. Also, you want to give out the policies in writing so it's fair. A lot of employees, like they might say, hey, you know what, I have 10 days vacation, but I'm pretty sure Joe has 20 days vacation. That's not fair. But if you have an employee handbook where here's our vacation policy, and maybe, yes, if you're there over 2 years, 5 years, 10 years, you get more vacation days, could be, it's there in black and white. It's going to stop people from having the perception that things are unfair. Because if the perception is that things are unfair, that could cause people to say, I'm being discriminated against. And I've seen this happen before, be it age, gender, sexual orientation, whatever it is. People go, I'm being discriminated against. But if I gave you an employee handbook and I told you all of our policies and I told you all of our procedures and you acknowledged it, you signed that you received it and that you read it, hey, it's there in black and white. If there's no perception of things being unfair, you're not going to get into litigation over things that could be unfair. And remember, litigation, litigation costs money. And I've said this before, Everyone who says, I'll sue you, has never been in litigation. Litigation is draining time, money, emotion. First of all, litigation costs a lot of money. Second of all, it takes a lot. You don't get resolution immediately. It takes months, years. And emotion, it eats you from the inside. Like, in the middle of the night, you'll just wake up thinking about litigation because it's a terrible thing. So what you want to do with these documents that I've been talking about is to avoid litigation. You want to have the operational documents. You want to have the restrictive documents. You want to have these worker documents. So with an employee handbook, I'll wrap up on this. You want to communicate what the procedures and policies are. You want to implement the handbook. Make sure that whatever the procedures and policies are, you are actually implementing. Don't just write something and don't do it because no reason having it in the first place. Also, if you're not implementing what you say you have, that could be problematic. You want to follow it and you want to revise it when necessary. Things change. And you might have an employee handbook from 5 years ago. Your business is 10 times the size with 50 more employees. You want to change things up. Okay. Another worker document is a separation or a settlement agreement. When an employee leaves you, a lot of times, you might feel, oh, you know what, we didn't have such a good relationship, or they're leaving on a bad note. Maybe they're going to come after us. So maybe we can settle it now and they can waive anything they might have against us in the future. I'll give them severance. I'll give you 3 months severance. Just waive anything you have. Now, a lot of times they don't have anything and they're happy to take your 3 months severance. But you want to just make sure that, because they might not be entitled to severance. So you're giving them 3 months pay. It's, it's like a gift. Oh, I'll waive any claims I might have had. I might not have any claims. So sometimes it's worth doing that. So that's a settlement or a severance agreement. Okay. Here's an agreement that I'm actually working on now. I think it's the first or second time I've ever done it before. So I'm going to read what it's called because it's long, and then we'll call it something else. A consensual romance in the workplace agreement, otherwise known as a love contract. Okay. Now, the love contracts don't force you to be in love with somebody because a lot of married couples wouldn't be able to legally sign it. But the thing is that many companies have rules against intra-office romance, where people work together and they, talk and they fall in love and okay. There's problems. There are problems with intra-office romance. So why don't employers like when people fall? Wouldn't it be nice? Oh, if all employees fall in love and they marry each other and live happily ever after, wouldn't it be great? Well, it might be great, but sometimes it's not great because not all relationships last. We know that. And not even talking about getting married. They might just go out and breaks apart and there are problems. Okay, because the thing is, if you have intra-office romance, it could lead to allegations of liability against the company. People can say that there was harassment, that they were forced or coerced into a relationship with somebody who's maybe more senior than them. So you want to have a love contract, and the love contract is going to say a few things. It's going to say the relationship is entirely consensual, that it's free from coercion, there's no harassment, there's no intimidation, that they went into it on their own volition, they liked the person, and they got involved in the relationship. They weren't forced into the relationship. You want them to have that in writing and signed. It's important. And then you want them to acknowledge that you have an anti-harassment policy. Now, where would you have the anti-harassment policy? In your employee handbook, right? You don't have the employee handbook, you don't have an anti-harassment policy. So you want to make sure you have all these things. So you have these employees sign a love contract. So later on, they can't claim any sort of intimidation or coercion or harassment. Because if they make that claim, one of these I'm not a litigator, one of the litigation attorneys who likes to litigate employee issues is going to come after the company saying that the relationship was forced upon this person. They didn't really want to get into it. They felt compelled to do it because the person was a higher up. They felt their job would be in jeopardy if they didn't get into a relationship. And you'll be like, oh, really? Here's my love contract. Look what they signed. They weren't coerced. They weren't intimidated. They did it on their own volition. They understood the anti-harassment policies, and they still decided to go through with the relationship. Guess what? Take your case and walk away. That will protect your business. It's not a big deal. You got the employee handbook with your policies. You have the love contract by any office romance. You're taken care of. That's the last worker documents I want to talk about. The last group of documents I want to talk about are intellectual property documents. So intellectual property is extremely valuable to any type of business. Sometimes the entire value of the business is the intellectual property. So you want to make certain that nobody else can use it, at least without paying you or compensating you. That's the reason you own the intellectual property. So first thing you have to do is you have to protect your company's intellectual property. There are three main types. There's patents. And that would be like an invention. So an example of a patent would be the light bulb. Who has the patent on the light bulb? Thomas Edison, right. And another patent would be the iPhone. Apple has the patent on the iPhone. So patents don't give you the right to do something. I'm Thomas Edison. I invented the light bulb. I registered my patent. Now I have the right to use the patent. No, you have the right to make a light bulb because you invented the light bulb. What a patent does, if it's registered, is it excludes everyone else from doing it. I can't say, hey, you know what? Here's an iPhone. I want to go make my own iPhones. I can't do it because Apple's patent on the iPhone excludes me from doing it. And you know, that's a pretty valuable patent. So the point is that you have these intellectual property issues that are very valuable to your company you might not even know you have. Now look, not everyone's in a business where they have patents. Patents is something where you're inventing something great value. But there are two other types of intellectual property I want to talk about. There's trademarks. Now trademarks would be like a word, name, phrase, symbol, logo, tagline that describes your company or product. So let's see. Google is a trademark. Walmart, the Walton Family Market became Walmart. That's a trademark. Apple is a trademark. Nike. Here's 3 different trademarks on Nike that most people know off the top of their head. The company name Nike is trademarked. The logo, the swoosh, is trademarked. And what's Nike's tagline? Just do it. Now, if I say, I'm Neil Greenbaum, I'm an attorney, just do it. And I start advertising just do it as my tagline, which probably wouldn't make any sense. But if I started advertising just do it as my tagline, guarantee you Nike's attorneys are going to send me a cease and desist letter saying you're infringing on our trademark. And they'd be right. They have the trademark. It's registered. It's theirs. Okay. So trademarks are based upon class. So that's why you have a lot of companies with the same trademark name, but they do totally different things. Apple computers, Apple Records. The Beatles had Apple Records. Now, those companies did fight at one point. Delta Airlines, which will fly people around the world, not today. Delta Faucets, which will maybe make faucets in your kitchens and bathrooms. Or Delta Dental, which is a large dental conglomerate. United Airlines, United Van Lines, Domino's Pizza, Domino's Sugar, not exactly the same. But my point is like they do different things so the names can be similar. But the trademark itself has value. So it could be the name of your company, the name of a product. It could be your logo, your tagline. It could be anything like that. So it has value. You should register it and you should protect it. Last type of intellectual property is a copyright. Now, most people think, oh, what do I have a copyright for? A copyright is usually some kind of musical, artistic, written. But if you're in a business where you create things, let's say you create websites or you create apps or you have code or something like that, you can copyright that and it has a value. And if somebody tries to infringe upon it, then you have the right to stop them from doing so unless they compensate you, which is what you want to do with intellectual property. So example of a copyright would be Harry Potter. It's a copywritten character, a Beatles song, or code or an algorithm or something that you're working on in the technical field will be copywritten. So like I said, intellectual property can be extremely valuable to a business, and it may be, under certain circumstances, the most valuable thing your business has. So let's say you did register or filed for or protected your intellectual property in whatever way you had to do. Okay, so then what else do you do besides registering it? Is there any other way to protect it? Of course there is. Through documents, through contracts. So the first one is intellectual property assignments. Now, you want to make sure your business owns the intellectual property. If your business doesn't own the intellectual property, it will not have the value of the intellectual property. I'm going to give you 2 examples where you have to be careful with this. So let's say you go into business with somebody and you're creating an app, but the person who's a tech person actually wrote the code for the app before you started the business and actually filed for it, registered it. Then you form a corporation, and now you're in business for a couple of years, you, him, maybe another partner, and then 3 years from now, they want to buy out your business. Someone comes, they want to buy out your business. Great, we're going to get a paycheck. So what they do is, during due diligence, when they're going to buy your business, they discover that the copyright on, let's say, the code was taken out by your partner before the corporation, and it was taken out in his own name. So your corporation doesn't even own it. Your partner does. Well, that's a problem because you're selling the corporation, and the reason you're being bought is for that intellectual property. So what you do is you have an intellectual property assignment. You have all your employees and all your partners from day one assign their interest in any intellectual property that they work on in the business to the business. That way the business owns it. I'll tell you a good story. So this guy, Arthur Fry, most people don't know who he is. He worked for the 3M Corporation about 50 years ago, and he was in a church choir. I am not in a church choir, but I have a book that we use in synagogue. And he would sing in the choir, and he had a hymnal, it was called, and he'd put paper in the hymnal to keep his page. When he turned the page, the paper would fall out. So he knew that there was another guy, Spencer Silver, worked at 3M, who had created an adhesive 5 years earlier. He said, you know what? I'm going to get some of that adhesive. And he went and got it. And the only paper in the office was yellow. He attached the adhesive to the yellow paper. He put it in his hymnal, and it stayed in. And what did he invent? The Post-it note. Okay. Now, is he a billionaire? I mean, they sold billions of dollars, I'm sure, worth of Post-it notes in the last 40, 50 years. Is he a billionaire? No. Why? because he works for 3M. His job was to do things like that. And I'm sure he signed an intellectual property assignment with 3M. 3M made the money. He didn't make the money. Maybe he got bonus and he's well known for it, which is great. But my point is, like, 3M wanted to keep the value, because the value of that intellectual property should be in the company, not in any individual employee or partner who works for the company. The last document that you could use, other than registering your intellectual property assignment to protect your company's intellectual property, is an intellectual property cooperation agreement. Now, a lot of times people might assign you the intellectual property and then they quit, they go into another job, or they retire, whatever it is. Now, you want to make sure, like, I need you to come back and sign something that's going to help us make sure we have this intellectual property and it adds the value to our business. So it's a cooperation agreement whereby they are going to come back and sign anything that would, in other words, cooperate with whatever is needed for the company to protect themselves with regard to the intellectual property. So those are the main types of documents. Operational documents you need restrictive documents, you need worker documents, and intellectual property documents. And your company should have all this. And we're living in a very interesting, precarious time, and I understand that. But the thing now is we all have a lot of time, and like, you might not have had time in the past to think about these things, but now you have some time. So what I advise people is you probably should spend a few minutes or hours looking through the documents your company has, see what you have, see if you have. If you don't have it, you need it. If you have it, it's not good, you need to change it. And it's a good time to do that right now. And I know a lot of people could talk about, like, Grant Cardone, the 10X rule, and it goes 10X, I'm going to 10X your revenues, 10X your earnings. Well, I'm going to tell you something. If you need a document and you wait until it's too late, it'll cost you 10X. Okay, so my point is, if you have some time, take that time now and spend time looking through your company's documents, see what you need. Anyway, if there are any questions, I'll take them. If not, I appreciate everybody. I don't see any questions. I appreciate everybody coming. If you want to get in touch with me, I'm on LinkedIn at Neil Greenbaum, or you can make a 15-minute call with me, talktoneil.com. I don't charge for it, and I'd be happy to speak to anybody. All right, take care of yourself. Have a great day.